Hey everyone, here today to talk about like a really straightforward concept that occurs sometimes in the family law context, but it's also something that's frequently overlooked. You know, pro se litigants, attorneys who maybe only dabble in family law, and even some family law attorneys that I've seen here, who I've seen here in St. Louis, have made this mistake. And the issue here is retroactivity and what that means. So let's talk about a common scenario in divorce cases, custody cases, or motions to modify. You file it. Say you believe that you're entitled to $1,000 a month in child support, and say you filed either a divorce or a custody case. Well, you file the case, and right now, when I'm making this video, it's December of 2019. So let's say you came into the office today and we filed your petition today. We are not going to trial in your case tomorrow. There's going to be some delay between the time we file this and the time the judge rules on the motion or the petition or whatever it is we're filing. Sometimes it can be a month. So you may get a resolution in January, in which case what we're talking about today doesn't really matter a whole lot. But it could take much longer. It could take a year if it's a motion to modify. It could take 2 years if it's a divorce case. So your case could go on for a long time. It could even go on longer. And the issue then becomes, and you're going to say, well, my case isn't going to trial for a long time. I may not settle my case. In the meantime, I should be getting child support, right? Or I should be getting maintenance. Very common concern. And so the law is set up in a way that if, for example, in your case, we file it now, we go to trial, say a year from now, say we can't settle it. It's one of those odd cases that we can't settle, we have to go to trial. And say we go to trial at the end of next year, end of 2020, December 2020. And then let's say the judge enters an order saying that you're entitled to, excuse me, $1,000 per month in child support. That's great for you at that point in time because you get $1,000 per month going forward. December of 2020, January of 2021, February of 21, you're going to get your $1,000 per month. But you're going to say, you know what? I should have been getting the support going all the way back a year. And my blankety blank spouse, husband or wife, got away with one because he or she dragged this case out for a year, didn't settle it, and dragged it out for a year. I shouldn't be penalized. Well, that's great. And don't worry, because the law and various laws afford protection for you. And what is allowed is that if your case is pled properly, the judge can award retroactive support. And what that means is that the judge in December of 2021, this video is horrible, excuse me, in December of 2021, the judge can say, I'm ordering the support of $1,000 per month going forward. Great, we expected that. The judge can also say, sir or ma'am, your pleading contains a request for this relief. So I can order support retroactive all the way back to the day that you filed this case or shortly thereafter. It's actually either the date of service or the date you file your financial statements, whatever the case may be. I can order that change retroactive all the way back to December of 2019, the day you filed, roughly. And so you will have gone to trial then, settled your case or gone to trial a year later, December of the year 2020, you get your $1,000 a month going forward, but you're also going to get your retroactive award going back 12 months prior. So you're going to start out with a judgment against your ex for $12,000 that's due and payable immediately, plus, or collectible immediately, plus you're going to get your $1,000 a month going forward. So are there any tricks to doing this? There aren't any tricks, but you really need to make sure that in your pleading, whether it's a motion to modify, whether it's a petition for dissolution of marriage, whatever it is, that you are actually asking for relief, retroactive, back to the day when you want it, or back to the day when you're entitled to it. If your petition doesn't have that, if your motion doesn't have that, you're out of luck. You're not going to get it. And it's a very common problem, to the extent that pro se litigants, when I see people file paperwork on their own, they almost never ask for it. And so, you know, it does cut both ways, because you can, if you're filing a motion to modify, you also want to ask for that retroactive relief. So let's say another example is you're a woman who is paying your ex-husband, say, $1,000 per month in child support or maintenance, and years later, circumstances changed, and you are entitled to a modification of that. So you file your motion to modify, and you ask the court reduce that amount, reduce it either substantially or eliminate it so that you don't have to pay that obligation. And then let's say your ex-husband drags the case out for a year. Okay, same scenario. If you've asked that that relief be made retroactive back to the day of filing, or back to the day of service, whatever it may be, the judge has the authority to make that change retroactive and give you a big credit instantly if your case finally goes to trial. Now, what law applies? There are a couple different laws. So you're looking at Missouri Revised Statute 452-340. That's 452.340. And then you're also, if you're in St. Louis County, and a lot of counties have a similar rule, but in St. Louis County, your local rule is 68.12. Now, both of those allow this retroactive relief. Now, the final thing I'm going to talk about is if you're an attorney and you pick up a file, whether it's your file, it's a case that another lawyer's been handling, or it's somebody pro se who comes into you and they started the case on their own and they got into a quagmire and they want to hire you, and you take a look at the pleading on file and you say, oh my gosh, it doesn't have a request for retroactive relief, what do I do? Well, you take a look at Missouri Supreme Court Rule, or Rule of Civil Procedure 55.33, and it relates to relation back of amendments. So what you're going to do is you're going to go in, you're going to file your motion to amend your pleading, and you probably are going to have to get relief. You're going to have to get leave of court to file that, unless it's a motion to modify and no answer's been filed. Then you could do it without leave of court potentially. But other than that, you get leave of court, you file your amended pleading, and then the amendment almost certainly will, in your case, will relate back to the date of the original filing. So again, really important to ask for retroactive relief. You know, even if you're going to waive it in a settlement or whatever it is, you want to make sure that's in your pleading.